Hi friends, happy Thanksgiving. This is Turkey Week here in the US for those of you who aren't familiar with this holiday. We get together with our family, our friends, and we just give thanks to God and to each other for the love and support that we've shown each other over the past year. Friends, I appreciate you. Thank you so very much for watching McBean Immigration Law TV. Thank you for sharing my videos. Thank you for commenting. Thanks to those of you who from time to time send me super encouraging words of appreciation. I love it. Thank you so very much. If you're watching and you haven't yet subscribed, go ahead and do so right now, because each week I publish videos on hot topics in immigration, and I do a lot of teaching on a lot of different subjects related to immigration. So keep watching McBean Immigration Law TV so that you can become smarter about immigration. So the question in this short video today is simply, what should you do if you've been denied your petition for a green card after your spouse filed for you? This one is very specific to marriage cases, because marriage cases are a very complicated area of immigration, right? Because there's fraud that is very much a part of many petitions that go before the U.S. government. And so the government takes extra scrutiny, extra measures to scrutinize marriage-based petitions. So if you had petitioned for your spouse and the spouse was denied, the first thing you need to think about is, what was the reason for the denial? What was the basis for the denial? Because if the basis is something that you can cure, then you can go ahead and cure it and move forward and reapply. But if it's not something that can be easily cured, you're going to have to really think this one through. So let's break this down in this short video. We're not going to be too long in this video. So first of all, if you get a denial based on the fact that, let's say, for example, you petitioned for your husband and he applied for adjustment of status, which is that one-step process to a green card here in the US, meaning that he doesn't have to travel back to his country to be interviewed by the US Embassy in order to get the immigrant visa. So if you petitioned for him and he applied for adjustment of status and that adjustment of status was denied because maybe he's not eligible to adjust his status. Why? Because he entered this country without inspection. He entered the country without inspection. He is not eligible to adjust his status unless he is a VAWA petitioner, right? He is an abused spouse of a U.S. citizen or a green card holder, and he is trying to self-petition for a green card. In that case, if he had entered the country without inspection at a border by a border agent, then certainly there's an exception in the law that will allow him to adjust his status right here. So he was denied on the basis of not being eligible to adjust his status. So that's curable. That is curable in some cases. It's curable by him having to file a waiver application to ask the government for forgiveness, right, for unlawful presence. That's really what he's asking for forgiveness about, unlawful presence, so that he can then go back to his country and be interviewed by the embassy there without facing that 10-year or 3-year bar to reentry. So that's one issue, right? So if the denial is based on something that is curable, in some cases it may be curable with a waiver. And in other cases, the person may not be eligible for a waiver, in which case it's not curable. Okay, so that person will need to find another pathway to a green card, if at all possible. So let's say you get a denial based on the fact that after your second interview with immigration, you guys went on that Stokes interview with immigration, and you were denied because the immigration officer believed that your marriage is not it's not a genuine marriage. It's not bona fide marriage, meaning that they believe, I should say, that you entered into this marriage to evade or go around immigration laws, in which case The letter will say that they will explain all the discrepancies between your answers during that interview, and they will say that you didn't supply enough evidence to prove bona fide marriage, and they believe that your marriage was entered into so that you can get around immigration laws. That one is a much, much more difficult situation to cure than some smaller defect with your application. So if, let's say, for example, you get that kind of denial letter and you want to reapply, you can reapply by proving bona fide marriage. You can try again. If you had a real marriage, you can reapply and provide the government with all of the evidence that it really is looking for. Okay, if you could reapply with the same spouse. But let's say you marry another person and you want to apply again, right? You have a bigger burden to overcome. You will have to prove that your first marriage, that first denial, you would have to prove that that first marriage really was a bona fide marriage, and the second marriage is bona fide. So you have like this double standard that you'll need to work on in order to get that green card approval. So these are some of the issues that people face during the denial process. Again, you have to think about whether the denial is something that is curable, in which case you can reapply, or whether it is something much more complex, in which case you absolutely need to work with a lawyer before you even think about reapplying. Okay, so friends, I hope that this short video was helpful. I know that some of you are saying in your comments that you'd love for me to get into more details about the topics that I discussed, but there's just so much that I can say in these short videos, friends. Please, again, have a wonderful Thanksgiving holiday with your friends and family. And friends, I will see you in the next one. Bye-bye.